Welcome to our presentation covering Chapter 14. This title covers the topics of title, the risk of loss, and warranties. We'll see as we go through this chapter that the title and risk of loss are very closely associated with terms, with each other. They're very associated to each other. But warranties is certainly a related topic, but is a little bit of a different topic as well. So let's get started. So what is a title? Well, the title is what you think it is. It is the right of ownership with respect to property, and this property can be real or personal. Well, of course, when we talk about real property, we're talking about land, and we're talking about personal property. We're talking about pretty much anything that isn't real property and isn't intellectual property. So title involves the right to possess or to use that particular item. So what is risk of loss? Well, risk of loss is the financial responsibility that would exist for goods that are damaged, lost, or destroyed. If I own something and something happens to what I own, then I bear that risk that, let's say I have a car and I'm in a car accident. Well, guess what? I'm out money. If you own the car and it gets destroyed, you're out money, but I'm not out money because I don't own the car. So you can see how title and risk of loss usually go hand in hand. If you have the title, you usually have the risk of loss. If you have the risk of loss, you probably have the title. These are very closely associated with terms. Now, as you are engaged in selling something or buying something, you want to think about when is title actually going to change. I mean, most of the time it's pretty straightforward. If I go to a Subway and I buy a sandwich, I give them $5 or whatever, and they give me the sandwich. And at that moment, when I'm passing my $5 bill to them and they're handing me the sandwich, that's when I get title to it. In transactions like that, it's probably not so very important that you know exactly when the title transfers. But there are other times where there's a delay. For example, let's say that I go onto Amazon and decide to buy a book, War and Peace. And I enter my credit card information and complete the transaction, hit the button. And that happens on, we'll say, Monday. But I don't actually get my copy of the book War and Peace until Thursday. Well, who owns that book from the time that I enter my credit card information until it arrives at my front stoop? I mean, when it gets to my front stoop, clearly I own it, I possess it. Let's assume that the credit card transaction successfully occurred, and so Amazon has gotten its money for the book. But there's a 3 or 4 day period of time where it's not 100% clear to the casual observer who actually owns that book. When does the title shift from Amazon to me, the consumer? When does the risk of loss occur? Let's assume for a second that once the book is dropped off at my house catches on fire, and unfortunately the book gets burned up. I mean, it's probably the least important part of the story, but still the book is destroyed because it was on my front stoop and my whole house was destroyed. Well, in that situation, I probably had title and I probably had the risk of loss. But let's imagine that 5 minutes after I hit the button completing that transaction on my computer, and I actually get the receipt saying, yep, you've completed your part of the transaction, your credit card went through, everything's good to go. Well, let's assume 5 minutes after that moment, unfortunately, Amazon has a terrible warehouse fire, and that book that I thought I was buying gets burned up. And in fact, all of the copies that Amazon had in that warehouse of War and Peace all burn up. So even though they hadn't actually selected the one that I was going to get, there's not any to get. They're all burned up. So at that time, did I own that book? Did my copy of that book get burned up? Did I bear the risk of loss? Did I have title? Probably not. And so you can see how there's an analysis that goes forward with this. Now there's a particular answer for here. I'm not really focusing right now on which answer is the correct one. I'm just trying to expose you to how you look at these issues and why these issues might be important. Now, at the end of the day, if you're buying a single paperback version of War and Peace, we probably don't really care when the transfer happens. But if we were buying, say, a Maserati, we suddenly start caring, right? We care about who's going to pay for it if something bad happens to it. So as you can see, it's really important to know when that title passes through the transaction. This is an example of a Texas certificate of title for a car. We actually pass a piece of paper when we're selling a car or a boat or some other thing. And typically the thing that we talk about having a title for is when it's quite expensive and quite mobile. So it's pretty easy to imagine someone stealing that and trying to maybe sell it to somebody else. Things that are of relatively trivial value and or aren't highly mobile, you don't need to have this piece of paper. But if we didn't have this paper system, if I stole your car, then there was no expectation there'd be that I'd be able to prove my ownership through a certificate of title, I could sell it to anybody and they would assume, well, I mean, Groover has the car, so surely she belongs to her. And you can see how that could result in lots and lots of problems. So we do have a piece of paper that we use in a few types of transactions. But most of the time, even when title is transferring, we don't have a piece of paper about that. That doesn't mean that title isn't transferring, it just means we don't have a piece of paper about that topic. So don't confuse the fact that we sometimes have paper and sometimes don't to mean that somehow or another title isn't transferring when we don't use the paper. Okay, so let's talk through a few scenarios in which title is passing from the seller to the buyer. Okay, we may recall these terms. We talked about them in an earlier chapter, the idea of a shipment contract. Okay, so with the shipment contract scenario, let's see if I can get this to work. Here we are, shipment contracts. The title and loss of risk pass when the goods are placed on the carrier. And this makes sense because keep in mind that the seller, as soon as he ships it, again, that word ship right there is really important. See if I can get it to be a pin here. Ah, here we go. As soon as he puts it on the ship, or as soon as it kind of leaves his physical control, he can kind of wash his hands of it. Now it's on the common carrier and or the owner, the buyer, if something bad happens to it. That risk of loss has transferred at that time, and usually, almost always, the title will transfer at that time. In a destination contract, the answer is going to be the reverse because the seller doesn't avoid the risk of loss simply by handing it over to the common carrier. The seller is going to continue to have that risk of loss until it is delivered to the buyer. So in that scenario, the title and the risk of loss do not pass until the buyer gets it. When the goods are not delivered to the buyer, they may be delivered through a transfer of a document of title, like a bill of lading or some such thing. In this case, title transfers when the seller gives the buyer the document of title. So in this situation, I might give you the document, even though I'm not giving you the stuff, at that magical moment, you have acquired ownership and you can go ahead and proceed with respect to that transaction as if you owned it, because you do own it. And after I give you that sheet of paper, let's say 5 minutes later, whatever it is burns up. Well, you're just out whatever that item might be. I don't have any duty to replace it at that time. If no shipment is necessary, again, the example of me going to Subway and buying the Subway sandwich, title is going to pass when the contract is made. When I say I would like that meatball sub, and they say okay, and they make me the meatball sub, and they hand it to me, and I hand them the money. There we have that transaction. Let's consider the situation when I buy the Ginsu knives. You know, I'm up late, 2, 3 in the morning, and I see a commercial for Ginsu knives. And they say I can try them before I buy them. I can have them for 30 days to see if I love them, and if I don't love them, I can send them back. Well, that's a sell on approval. So they send them to me. I have 30 days to enjoy them, and as long as if I decide I don't want them, as long as I have them in the mail by the 30th day, I do not have to buy them. Under those situations, the title isn't going to transfer to me until that 31st day because I don't own it. The Ginsu company would own those knives until that point. Now, these are just some examples of situations where we have the title transferring, but honestly, the parties can do whatever they want. Generally, Title is going to transfer when the stuff transfers, because it makes sense. You know, you want to have title and risk of loss transfer at the same time, and it makes sense that if I have possession of the stuff, it makes sense I ought to bear the risk of loss, because after all, I'm the one who can protect the stuff. If I have custody of the car and I bear the risk of loss, if I know that there's a hailstorm coming, I'm going to make sure that the car is in the garage. If I don't bear the risk of loss, well, I don't really care. I'll just leave the car out on the driveway, and if it gets dinged by hail, what do I care? It's not something I own. It's not something I bear the risk of loss. So it makes sense generally to follow possession with the risk of loss in the title. Now you may be thinking to yourself, why do we marry up risk of loss so closely with title? One of the big reasons has to do with insurance. Actually, we'll talk about insurance in a second. I thought this was the next slide here. If a buyer rejects goods because they're non-conforming, in other words, they aren't what that person had ordered, or at least the buyer is saying they aren't what they ordered, the title and the risk of loss, of course, will revest with the seller. Now, this occurs even if the buyer shouldn't have rejected them. In other words, they really were conforming goods. The buyer was just not doing what he was supposed to. And the reason that the title revests is that when they are returned to the seller now possesses them. And very likely the seller will go ahead and sell them to somebody else, or at least that's a possibility. Well, if the seller gets them and he doesn't have title, he can't resell it. I mean, that's really not anybody's interest. Why does the seller want to hold this stuff that he can't sell? And why would the buyer want to continue to have title under those circumstances? It makes sense, even though it may be wrongful or it may be rightful of what the buyer did, it makes sense for everyone concerned to go ahead and revest the title with the seller, and the seller can take care of it. Then maybe the seller, maybe the items that he had thought that he was selling to the buyer would have generated to the seller $300. And now that the buyer has returned them, and now the seller can only sell those items for a total of $200, so now the seller is out $100. The seller may well go to the buyer and say, you owe me $100. You owe me the difference of what I was expecting to get from my sale to you and what I was ultimately able to get through my cover situation. And so you need to pay me the $100. And of course, the buyer's response may be, well, the goods that you delivered to me were non-conforming. I had the legal right to reject it, so I don't owe you any money. That's where there will be an interesting legal issue. Typically, when insurance is involved, the risk of loss will be with the party who has the insurance. So if there is a shift of a title and risk of loss, you're going to want to have that track with the insurance. Because if you don't have a risk of loss in the transaction, you don't have an insurable interest. You can't insure something that you can't, that if you lose it or that if it is lost, it doesn't harm you. That's a general rule associated with insurance. So I can't, for example, I can't put insurance on your car. It's not my car. So if something happens to your car, let's say there's a hailstorm or your car gets stolen or you're in a car accident, that's not really my problem. And so insurance companies would say to me, Groover, that's not your car. You can insure your car, but not somebody else's. And so the risk of loss usually is going to track with title, and you're usually going to need to have that risk of loss in order to have an insurable interest. So if I happen to be carrying auto insurance on my car and I sell my car to you, the second I sell it and you get possession of the car, the insurance company are going to say, oh, Gruber, you're done. We don't want your business anymore for that car. Even if I say, but I'm willing to pay you premiums. No, we're not interested, because after all, you don't have any reason to want this car anymore. You don't benefit when it's in good condition. You're not harmed if it's in bad condition. Okay, let's talk about the 3 types of title you can have. And actually, the first type of title really isn't a title at all. This is like a oxymoron. An oxymoron is an expression that is logically inconsistent with itself. I'll give you an example. The Walking Dead. You may have seen the TV show. It has to do with zombies, but the term Walking Dead is inherently an oxymoron because, I mean, you can be dead or you can be walking. But aside from zombies, you can't be both. If you're walking, you're not dead. If you're dead, you're not walking. So because these present a situation that is internally inconsistent, we call that an oxymoron. And the void title is a similar thing. Something can be void or something can be a title. If it is a title, it's not void. If it's void, it's not a title. So while you'll hear people talk about the term void title, what you're really saying when you say void title is you're saying what this isn't a title at all. It's a little bit like if someone were to say, that's my divorced wife. Well, either that's your wife or that's your ex-wife. Can't really be both. I guess you could have divorced your wife and remarried her, but then she's not really your divorced wife anymore. So terms like that are inherently inconsistent. So I just want to make it clear that a void title is not a type of title. It's evidence that there is no title. You almost could replace the word void with no title. Okay, so let's go through these. But before I go through these, I'm going to draw an analogy to family law that I think can help clarify some of this. So let's think about the first type of a title, which is valid title. I mean, this is what usually happens. This is the success story of title law. It's what happens the vast majority of times. And this is what happens in the area of marriage. You have, we'll say, Bob and Mary. They want to get married. Neither one have been married before, or if they have been married before, they've gotten a divorce and gotten all that resolved, or their spouses have died, or whatever the circumstances. They're free to marry each other. They get the marriage license, they have the ceremony, they sign all the documents they need, they have the witnesses present. At the end of that ceremony, they are really and truly married. They have a valid marriage. Of course, there's no ownership involved here, but that's an analogy. So we would say we'll say a valid marriage is analogous to the idea of a valid title. But let's imagine there's a couple of quirks, or maybe a couple of different scenarios, and we'll go through. One scenario might be that Bob, though he is divorced, he's only been divorced 29 days when he and Mary marry. Well, under Texas law, you cannot marry until 30 days have passed after your divorce. And so on the date that Bob and Mary marry, Bob is not legally free to marry. But let's say they're not aware of this aspect of Texas law. They go ahead and get married. They go on and have a happy marriage. They're married for 30 years. We would say that they had a annullable marriage initially. There was a technical problem with it. They should have waited one more day to get married. But 30 years later, we wouldn't say, well, gosh, I mean, let's say 30 years down the road, Bob and Mary have a quarrel and Mary decides she wants to divorce Bob. Well, we would say, no, Mary, you ought to, if you want to get a divorce, that's fine, but you need to get a divorce. You can't get an annulment. Mary might say, well, I've been researching the law, and actually, 30 years ago when Bob and I married, we should have waited an extra day. It was unlawful in Texas to get married within 30 days of the divorce decree, and so I ought to get an annulment. Well, maybe you could have gotten an annulment. You probably could have gotten an annulment if you had, within a week or 2 or 3 applied for an annulment, given the fact that there had been a technical problem with the marriage. But now it's been 30 years. You've had 4 kids. This is a little bit extreme. You should get a divorce at that point. So you could have annulled the marriage, but you didn't. So this is something that you can back out of, but if you choose to continue in the marriage, it's a perfectly good marriage. So an annullable marriage is one that can be ended, but if it's not ended, it becomes a valid marriage. Let me give you another example of an annullable marriage. Bob and Mary are first cousins. Now, it used to be in Texas that first cousins could lawfully marry. And in fact, it was rather a common thing in small town Texas. There's not a lot of people to date. And so it wasn't unusual for people to marry their first cousins. About 20-ish years ago, though, in Texas, it became unlawful to marry your first cousin. Now, people who were already married were literally grandfathered into those circumstances. But let's imagine that Bob and Mary are first cousins. They've fallen in love. They decided they wanted to get married. They want to get married in Texas. They fill out their marriage license. I'm sure there's a question on that about being first cousins. They both fib a little, and they get married anyway. And then a couple weeks later, Bob and Mary have a huge fight. Mary decides, I don't want to be married to this Bob anymore. And so she goes to her attorney and says, I want an annulment. Bob is my first cousin, and this is not working out. Under those circumstances, that's probably an annullable marriage. If you decide within a few days of the marriage and you had a basis to get out of the marriage, such as being first cousins in Texas, then that would be an annullable marriage. You can get an annulment situation. That would be like a voidable title. So let's look at what a voidable title is. A title that arises when the goods were obtained by fraud, paid for with a dishonored check, purchased from a minor, or purchased on credit when the seller was insolvent. You can see each one of these cases, there's a bit of a problem with it. Something happened that really shouldn't have. Just like with the annullable marriage, Bob should have waited until 30 days. Mary and Bob shouldn't have married in Texas if they're first cousins. But it's not the worst problem ever. In a voidable title, some of these problems could be fixed. After all, you could submit another check that is honored by the bank. Or the minor could could turn 18 and could agree to honor the purchase. So these problems sometimes can be fixed, just like an annullable marriage can be fixed through the passage of time. But there are some marriages that aren't marriages at all. So let's imagine another scenario. And this is fairly disturbing. I apologize in advance. Let's imagine that Mary and Bob fall in love, and both of them grew up in an orphanage. They have found love after overcoming lots of problems. They marry, and Bob decides to do some research into his family tree. He doesn't have a lot of information about his family tree, but he gets what he can. And same thing with Mary. She decides, well, why don't I find out what my family tree is? So they research their family trees, and lo and behold, they discover they're brother and sister. Oh my gosh, how awful, right? Well, even though they didn't know they were brother and sister, they did nothing wrong by marrying, because obviously they couldn't have known that fact. But it's unlawful in Texas, and as far as I know, everywhere, to marry your sibling. And so Bob and Mary can't be married. There's no way to fix this problem. It doesn't matter how many priests and rabbis and ministers and judges married them. They can't get married. It doesn't matter that they didn't know. It's just not something that we're ever going to acknowledge is a marriage in the state of Texas, or honestly in any other state. So this is what we call a void marriage. This is a voidable marriage and annullable marriage. This is a void marriage, not a marriage at all. It's a title without any legal effect. It's a nullity. So that's the breakdown of the different types of titles. Let's talk about one of the kind of quirky things about a voidable title. So let's say that I knock on your door and I say, hey, I'd like to sell you, or actually, okay, let's change up. So let's say that we're sitting in the classroom and you happen to have a fancy water bottle. And I look and I go, gosh, that's so neat. I'd really like to get that water bottle. And you say to me, well, Gruber, you know, I have another one at home. I'd be willing to sell you this one for $10. Gosh, it looks great. So I get out my checkbook and I write you a check for $10. You take it, you assume it's good. I mean, I'm your instructor, for goodness sakes. You give me the water bottle, I head on out the door. And as soon as I'm out in the hall, I run into somebody who looks at my water bottle and says, hey, that water bottle is super cool. I've been looking for a water bottle. And I say, well, you know what? I'm willing to sell you this water bottle. And they go, well, how much? I say, oh, $10. How about that? So they pull out a $10 bill from their wallet. They give it to me. I give them the water bottle. In the meantime, you've gone off to the bank to cash the $10 check. Unfortunately, it's dishonored at the bank. They say, Groover doesn't have sufficient funds for this check, sorry. So you come back to me, you find me in my office, hey Groover, you wrote me a hot check, I want my water bottle back. Sorry, I don't have a water bottle anymore, I sold it to somebody else. Yeah, well, who did you sell it to? I say, well, I sold it to Bob. Bob was in the hall. Hey, I'll even tell you where to find Bob. So I give you directions to Bob. You go find Bob. You say, hey, Bob, give me my water bottle back. Bob's kind of surprised. What are you talking about? I bought that water bottle. I paid $10 for it. It's mine now. No, it's not, because the lady who had it, she didn't really own it because she wrote me a hot check. Well, who's right? Who actually owns the water bottle? Well, the law says Bob does. Let's go through this. And by the way, I have a video posted in the unit that kind of goes through these scenarios as well, so you might find that interesting to watch. So I had a voidable title, right? Because I wrote you a check and you gave me the water bottle. Because it was not a valid title because I didn't pay for it with a good check. But in this situation, once I got the voidable title, then I transferred it to a good faith purchaser. I mean, Bob had no idea that I didn't have a good title. He assumed I did. Why else would I have the water bottle? He assumed I had a valid title instead of a voidable or a void title. So when he paid me, that was the only reason why he was willing to pay me, what he got was a valid title. So I was able to transfer a better title to Bob than I myself had. And that's not the usual rule. Usually if you have a void title, all you can transfer is a void title. Usually if you have a valid title, you transfer a valid title. But sometimes when you have a voidable title, you can actually transfer a better one, a valid title. Now this doesn't mean that you don't have a remedy, because you of course can sue me to get, you can't get the water bottle back because I don't have it anymore, but you could get the $10 from me. You can see this is one of the reasons why criminals or other people are interested in getting rid of the stuff as quickly as possible, so that they can, well, number one, so they can hide the tracks of their crime, but also if they get rid of it before they're apprehended or identified, they're transferring a title that might be a valid title. So you can see here we've talked about the analogy of void title, which is like that marriage between siblings. Avoidable title is one with a problem, but maybe a fixable problem, like the marriage between first cousins. And then we've had the valid title, just a normal, ordinary, everybody did what they were supposed to type of scenario, just like the vast majority of marriages. Oh, by the way, going back as we're talking through the divorce scenario, so the valid marriage, the only way to get out of that is death or divorce. A voidable marriage you can get out of by annulment as long as you get it pretty soon. A marriage between siblings, guess what? You don't need anything. You never were married, so you don't need a divorce. You don't need an annulment. So that's kind of an analogy that helps maybe fill in the spots a little bit on how the titles work. Let's talk about entrustment. Entrustment is also a bailment. We'll talk about bailments in another chapter, but just if you've heard the term bailment, you may be thinking, this sounds awfully like entrustment. Well, you're right. And bailments, by the way, doesn't have anything to do with incarceration situations. Okay, so what is an entrustment? It's a situation in which the owner, the entrustor, or the bailer gives a good to a merchant, which is the entrustee or the bailee, who normally deals in these types of items with the intention that the entrustor will get the item back. So we'll talk about more examples in a second. So I might leave my car at the car dealership because the car dealership is going to fix my transmission. And I'm not going to wait there. The car might need to be there for several days. So I'm going to entrust the car to them. But while it's in the dealership's care, let's say there's a hailstorm that comes through and the bodywork on my car is damaged. Or let's say somebody accidentally sells my car to a customer on the lot. And so I can't get my car back. Those would be examples of situations in which the entrustee, the merchant, is going to be responsible for my loss. You can see in these scenarios that the merchant, the car dealership in my example, doesn't have title. He has possession, but he doesn't have title. Let's say that somehow or another my car is put in the wrong section of the lot. It's supposed to be repaired, but somehow or another it gets in the used car section. Somebody comes in looking for a good used car. He's a good faith buyer. He thinks that the car dealership owns this car. I mean, else why would it be in the used car lot? For whatever reason, that the car dealership thinks they own it too, or at least somebody thinks they own it, and so they negotiate a price. The good faith car buyer pays for it, drives the car off the lot. Under those situations, the good faith buyer has a valid title because the merchant had what is considered a voidable title under those situations. And so his title, the good faith buyer's title, is considered superior to that of the true original owner. And the reason for this is that the entruster, the person who owned it originally, can sue the merchant. But it may be difficult to find the good faith buyer. And in this scenario, the good faith buyer hasn't done anything wrong. The entruster hasn't really done anything wrong either. So both of them are kind of victims of the incompetence or the criminal intention of the merchant, depending upon the circumstances. So it's kind of a choice between two relatively innocent people, but the law has decided, you know what, this guy is going to get the title. Maybe it's because he possesses the car. Maybe that's kind of the tiebreaker in the situation. So the entruster is not out of luck. He can sue the merchant for the value of the good. Let's consider for a second Pete. Pete is the owner of this lovely jewelry store. You come into Pete's store and you happen to have a diamond ring, and you want him, the diamond's a little loose in its setting, you want him to fix it. He looks it over, he goes, you know, I can't do it right now, but yeah, I'll be glad to fix the setting. It'll be $100. So you take off your ring, you give it to him. He says, come back in 3 days. You come back in 3 days, he gives you the ring, it looks great. You decide to take, you pay him the $100, go home. When you get home though, it doesn't look quite right. There's something about the way the diamond looks doesn't look quite right. You start feeling like maybe there's something fishy going on here. So you take it to a gemologist. He puts a diamond probe on it. It's cubic zirconia. It had been a 1 carat diamond, and now it is just cubic zirconia. So that's, thousands of dollars that you've lost because apparently somebody in Pete's store has stolen from you in that situation. So you were the entruster in this transaction. Pete was, and you were the bailer. Pete was the entrustee or the bailee, and he did not take care of the item, or one of his employees did not take care of the item. So certainly under those circumstances, you can sue Pete and Pete's jewelry store for the loss that you have experienced. Okay, we talked about insurable interest before. Again, this is going to track with loss, a risk of loss. So insurable interest is an interest from whose existence the owner derives a benefit and whose non-existence would cause him or her to suffer a loss. Again, because it's an insurable interest, it's something you can buy insurance about, right? And generally, you're going to have that insurable interest up until the moment when the title passes. And the buyer is going to have the insurable interest as soon as the title passes to him or her, or as soon as the goods are identified. Once the goods are set aside, going back to my example of me buying the War and Peace paperback book. Let's say that in my particular warehouse, the warehouse that services my zip code for Amazon, they happen to have 50 War and Peace volumes. They all have the same cover, they all have the same publication date, they're all basically the same condition. I have ordered the War and Peace book, but they haven't actually pulled anything out of the bin for me. Let's say the way that they do things at Walmart is there's just a bin and the order filler comes along and grabs a volume. He could grab any of the volumes in there. He's probably going to do one on top, but there's several on top that he could grab just as easily as any other. So before the order filler comes, there's a big fire in the warehouse. All of the War and Peace books burn up. Well, my particular War and Peace volume hadn't been identified, so I did not have an insurable interest. But let's give another scenario. Let's say the order filler does come by. He grabs my particular volume of War and Peace. I mean, he could have picked any, but he picked this one. And he puts it in on a conveyor belt, and somehow or another it's associated with my account. Now, let's say there's the fire. While it's on the conveyor belt, it catches on fire and it's consumed. Well, in that situation, I did have an insurable interest because we all knew, or at least somebody knew, that that particular volume was the one that was supposed to be mine. Now, I probably didn't insure it, but under those circumstances, it's conceptually possible for me to have insured it. Let's consider the scenario where the seller delivers non-conforming goods to the buyers. Let's say instead of me getting War and Peace, somebody sent me, or Amazon delivered to me Grapes of Wrath. That's not what I wanted. Under this scenario, the buyer does not obtain the title, because let's assume I choose not to keep. And this is actually, it's not a very good example, because when you have mailed items like this, the buyer gets to keep them even if they're non-conforming. So let's imagine that I was a merchant here. So I'm not an end user. So I'm a merchant who's bought items from Amazon to fill my warehouse. And so I had ordered 50 copies of War and Peace, and they had sent me 50 copies of Grapes of Wrath. I don't obtain title under those circumstances because I'm planning on returning them to the seller, to Amazon. And so the seller under those circumstances continues to have an insurable interest. Now, if I am just that everyday consumer who gets on Amazon.com and orders, my single copy of War and Peace, and they send me Grapes of Wrath, the law provides an exception to this rule. The law says, Groover, you don't have to return it. You can just treat that as a gift from Amazon. And so I get to keep my Grapes of Wrath book, and then I'll reach out to Amazon and say, hey guys, you sent me Grapes of Wrath. Thanks a lot. I appreciate it. But what I really need is a War and Peace. And then Amazon will send me a War and Peace, hopefully, under those circumstances. So when it's an individual user and it's mail goods, I am going to get a title to it, even if it's the wrong book. I will not have to return it. But I will still be entitled to the right book. If the seller delivers non-conforming goods with a latent defect, latent in this context means hidden, not obvious when it is received, that is discovered by the buyer after acceptance, because here the buyer looks it over, but because it's a hidden defect, it's not obvious after a careful inspection, so he accepts it thinking they're conforming, but discovers later on they're not conforming. For example, let's say that I order 100 hair dryers, and I open up all the boxes, they all look normal, and I plug in every 5th one. So I plug in 20 of them. They all work fine. But you know what? One of the 100, one of the ones I didn't plug in, it doesn't work. It's dead. Well, that would be a non-conforming good. But it looked like it was going to work. It looked normal. I mean, there wasn't anything when I looked at it that would indicate that it's not going to work. And so that would be a latent defect. In that situation, the buyer has the risk of loss up to the buyer's insurance, assuming the buyer has insurance on that. And all risk after that is borne by the seller. So again, let's imagine that I'm in the business of selling hair dryers. The risk of loss I'm going to have while I have these non-conforming goods with latent defect. Okay, now we're going to switch gears and talk about warranties. So we've talked at this point about risk of loss and title, and now we're going to talk about warranties. So warranty issues come up once the buyer has possession and title, and of course has that risk of loss. So a warranty is related to the idea of risk of loss and title, but you can have risk of loss and title and not have any necessarily warranties, or not have warranties apply under those circumstances. And sometimes warranties can apply even in other circumstances. So they're not completely linked up in that way. So what is a warranty? It's a promise, either express or implied by law, with respect to the quality, fitness, or merchantability of an article of sales. It can be express or implied. Now, sometimes people get confused about express, and they think express means written. Certainly, warranties can be written, and that's a good strategy to have them be written. But when we say express, this includes, they may be expressed in any way. It can be an oral warranty. Implied would be a situation in which nothing is stated either verbally or in writing, but under the circumstances it's obvious it was the intent of the seller to offer a warranty. Let's dive a little deeper into this concept. So here's the express warranty. A warranty created by the seller in a contract for sale of goods in which the seller orally or in writing, so again, express means oral too, makes representations regarding the quality or condition of goods. So let's look at the methods that we might use to create an express warranty. So any statement of a fact or promise, any description of goods, or any sample or model. So let's say that I'm at Best Buy and I'm trying to select a printer. And they have 5 printers displayed, and each one of the printers has, coming out of the mechanism that feeds the paper, has a piece of paper there, which one would assume is an example of the quality of work that this particular printer would produce for me if I were to buy this printer. Well, I see a particular printer, and it has a beautiful color page that's come out of the printer, or at least it appears to have come out of the printer. And so I think, gosh, this picture is, the colors are so vivid, they're so crisp and clear, and so I really think this is the printer I want. I look at the price, it's a really good price compared to the other items, so I decide I'm going to buy that. I take it home, and then I realize, wait a second, this is a black and white dot matrix printer. It doesn't print a color at all, and it's not very crisp or clear in terms of quality. Well, under those circumstances, the Best Buy has violated the express warranty that the sample created in me. Another way that this could be some confusion is let's say Best Buy has little stands or little signs they put in front of their items that describes the model and the characteristics. And so I look on the model of the printer that I'm going to use, and it's XYZ123. And so I look for the description of the XYZ123 model. I find that, and I read the description, and it says that this printer has the capacity to print 1,000 pages on one ink cartridge. Wow, that's going to save me a lot of money on ink cartridges. I think I'm going to buy this one. Well, I take it home and I read the fine print, and well, no, it's only 100 pages. Someone, when they were typing up this sheet, added an extra 0. The description of goods created a warranty that the item does not actually satisfy. So you can see that when we have any kind of statement or promise, it can be an oral statement or promise by the salesperson or some kind of written document. There is going to be a warranty that's created. But sometimes statements made by individuals don't create warranties, and that's in situations where there's puffery or puffing going on. This is the exaggeration and talking up that happens when a salesperson is saying, oh, this is the best ever, you really ought to buy this one, you're going to love it. Well, none of those are facts. This is the best ever, you're really going to love it, you ought to buy this one. All of that is just opinion and possibly exaggeration. A puffing of that type does not create a warranty. You need to actually have a fact going on here. Now, this is an example, this picture. You can see we start out with this very attractive young woman, and presumably before the implication we're trying to have is that she looked like this minutes before, and suddenly she looks like this. Now, common sense would tell anyone there's no way this skin looks like this skin in a few minutes. It would take, massive plastic surgery, and probably even that wouldn't get her to that point. So we can look at this and know that this is not attainable. So common sense kicks in. That's why you may have read about various skin lotions and skin treatments and makeups that when you hear their statements, you're like, really? Can that product really do that? Well, probably it can't, and that's okay, because the courts would say, "Gosh, you couldn't have really believed that it was going to do that. Common sense should have told you that was a bunch of hooey." And so we're not going to hold the makers responsible because you shouldn't have believed that kind of silliness. We also have, in addition to express warranties, implied warranties. These are a warranty by the seller inferred by law, whether or not the seller intended to infer that, as to the quality or the condition of the goods sold. So let's look at some of those implied warranties. One is a warranty of title. If I remember going back to the example when I bought the water bottle from you with a hot check, and then I go outside and talk to Bob, and Bob sees my water bottle and goes, "Hey, I love your water bottle. It looks great. Can I buy that from you?" And I go, "Sure, $10." And so he gives me $10 and I give him the water bottle. I mean, I never said I owned it, but certainly Bob thought I owned it, and that's a pretty reasonable assumption because I'm carrying it around, right? Well, I had an implied warranty of title in those situations, a warranty that the seller, in this case me, had an ownership of the goods. I didn't really, as we talked about before, I only had a voidable title. But the law is going to imply that I actually represented to him that I had title even when I didn't. Another implied warranty is warranty against infringement of intellectual property rights, such as patent rights, copyright rights, and trademark rights. These are the three kind of categories. There's a fourth, but these are the three big ones of intellectual property rights. So let's talk about these for a second. What is a patent? This is something issued by the federal government, typically for 17 to 20 years, to a person who invents or discovers something that is new and useful. So this is, you typically we're thinking about this as being an invention. A copyright is an artistic statement. You don't actually have to submit this to the government, but it's some kind of a literary or artistic item, a piece of music, a novel, a recording of a play or something like that. All those would have copyright interests. And now we have, so I'm going to circle the word artistic here as a keyword. And then a trademark is a type of design, called design, that makes you identify a particular product. So for example, when you see a big yellow M in the sky, you know it's a McDonald's. When you see a swoosh on an item of clothing, you know it's a Nike item. These are signs that let you know that this is a particular product. It helps that product market itself. So if I were to sell you an item with a swoosh on it, even if I didn't say, "Oh, by the way, this is a Nike shirt," you would assume it's a Nike shirt, and you'd probably be willing to pay a little bit more for it than you would, something that isn't a Nike shirt. So I am infringing upon the trademark of Nike when I sell this item. And you could sue me because, in fact, it's not a Nike shirt after all. Similarly, if I take one of William Shakespeare, not William Shakespeare, he's been dead too long, but a more recent author's book, and well, let's say I take a book by Stephen King, and I change his name to Cynthia Groover and claim that, "Oh yeah, this is my book. Yeah, I wrote this book. Yeah, this is mine." You buy it, and then you discover later on that's really Stephen King's. That would be an example of copyright infringement. Let's talk about, these are important areas of infringement, but let's talk about probably the big one, a warranty of merchantability. This one is at least as important as the others. This is the warranty that I'm giving you that the item is free from defects and fit for the purpose for which it is intended. So going back to when I bought the hair dryers, you might argue and let's say this time I only buy one hair dryer. When I take it home, I plug it in, it doesn't work. The kind might say, "Well, I mean, we didn't know you wanted to use it to dry your hair. We thought you just thought it was attractive, kind of an artistic statement that you wanted in your bathroom. And it's very pretty. Look, it's got a lovely color to it. It's got kind of interesting shapes to it. We just thought you wanted something attractive. I mean, we knew it wasn't going to work to plug it in." Well, we'd all look at that company and say, that's crazy. I mean, people buy hair dryers not because they're beautiful, but because they dry hair. That's the purpose. So it's not fit for the purpose for which it was intended if it can't dry hair. So it breaches the warranty and merchantability. Okay, so let's consider the next topic, a warranty for fitness for a particular purpose. This arises when the seller knows that the buyer is relying upon the expertise of the seller in a particular purchase decision. Let's consider this more carefully. Here we have somebody. This is Angela. Angela has had a dream her entire life. She wants to bike from North Carolina all the way to Spain. She wants to get on her bike, have her scuba gear on, and just trek across the bottom of the ocean. So she goes into Richardson Bike Mart, and a salesperson approaches her and says, hey, interested in buying a bike from me today? Well, Angela says, yes, I am. I am interested in buying a bike. I want to bike to Europe. And he goes, oh, you want to bike around Europe? She goes, no, I don't want to bike around Europe. I want to bike to Europe. And the salesman is like, I'm not sure how you would do that since we're in North America. She goes, oh, no, I'm going to go to the Outer Banks of North Carolina. I'm just going to enter the surf there and just keep on going. But I'm concerned, there's a lot of pressure when you're that far underwater, hundreds of feet underwater. And I'm worried about rust, and I'm worried about, the terrain is going to be rocky and uneven. And so I'm just wanting to know which bike would you recommend for that? Well, let's say the Richardson Bike Mart person's thinking, gosh, I make a commission. So I mean, honestly, there's no bike ever that's been made that could do that. But I want to make a sale, and this person seems crazy enough to probably spend some coin on this. So he goes, well, listen, our best bike, the one that I would recommend for your particular plans, is the XYZ 4000. It's going to cost you $20,000 to buy it, but it's rock solid. It can definitely do that. So Angela says, okay, I've got $20,000. She writes a check. The check clears. She takes the bike home. She drives to the Outer Banks of North Carolina. She gets the scuba gear on. She gets on her bike. She goes into the water. She goes about 10 feet. She falls over. She realizes this bike is not going to make it across the ocean. She sues. She says, wait a second, you told me this bike was fit for a particular purpose, and it wasn't. Can she win? Well, yes, she possibly can win because the seller knew what she was planning on doing and gave his expertise about which one she ought to use. But let's imagine a different scenario. So this time Angela's going into that same Richardson Bike Mart, and the same salesman approaches her and says, how can I help you today? And she goes, listen, I need a super sturdy, durable bike that can handle getting wet. And the salesperson goes, well, we've got several models like that. What do you plan on using it for? She goes, well, I'm going to be riding it a lot. It's going to be some pretty wet circumstances. There'll be some water involved. Oh, okay. Well, this is the one I recommend. This is the one that's least likely to corrode or get any problems along those lines. And so Angela goes, so you think this is the best choice for me, given the fact I'm going to ride it hard and it's going to get wet? Yes, this is the best one for you, Angela. So Angela buys that bike. We'll say it's the same bike. For $20,000, she buys the bike. She takes it to North Carolina. She gets in the water. She goes 20 feet. She realizes this isn't going to work. This time she sues Richardson Bike Mart again, but she's not going to win this time because the seller didn't know what she really intended to do. She didn't make it clear. All she said was it was going to be ridden hard and it was going to get wet. That does not mean you're going to try to bike across the Atlantic Ocean. So under those circumstances, Richardson Bike Mart would not be responsible under a warranty for fitness for a particular purpose type of claim. Okay, so let's look at the Important Warranty Act. This is a federal law that plays a role here. This is the Magnuson-Moss Warranty Act. It's a federal law that applies to warranties. Here we've got gentleman. I don't know if this is Moss or Magnuson, but here's the gentleman. You can see this is a thing from the 1950s. Anyway, the federal law that applies to warranties for transactions for products used by households, families, or individuals. So this is a consumer law. And under this act, there are two types of warranties. We have full warranties and limited warranties. And the names are pretty descriptive, a pretty good description of what they are. So what is a full warranty? It's a warranty that is not confined to specific defects and covers labor as well as materials. This is the category that most warranties are. It's going to have a time limit. I mean, if I buy a car, let's say my great-grandparents bought a Model T in 1910, well, guess what? It's not going to still be something I can take it to a Ford dealership and go, wait a second, I got some wear and tear on the car, I want you to fix it. They'd be like, no, that car is, you know, over 100 years old. You're kind of responsible for it at this point. So there's going to be a limitation to it, but this is covering the entire car or whatever the item is. We also have limited warranties, and these are going to be, you know, limited to particular categories of problems. And you have to obviously specify what's covered and what's not covered in a limited warranty. We can get limited warranties whenever the seller excludes particular categories of items, or perhaps exclude entire categories of warranties. So for example, a seller might exclude the warranty of title, or the warranty of patent, or the warranty of infringement of copyright, the warranty of infringement of trademark, or the warranty of merchantability, or the warranty for fitness for a particular purpose. All of those can be waived, or the owner can exclude. The seller can exclude. But these exclusions have to be in writing. If you're going to exclude merchantability, you have to actually use that word, and they have to be very conspicuous, clearly visible, easily seen. You can see in this warranty, they put it in bold, they underlined it. Sometimes they will use all caps. And so that's what you need to do to make it really, really clear. Okay, so now we're going to talk about, I've been talking before about how ownership and warranty are very closely aligned, and they certainly are, but they're not lockstep. And this is where I'm going to get into that area where there's a little bit of distinction here. And this is the issue of privity. Now, we've talked about privity before. We talked about this in the situation of third-party beneficiaries, where, you know, two people, A and B, enter into a contract to benefit C. So what rights do C have? Well, C isn't in privity, isn't a party to the contract. And so most of the time we decided that C doesn't have any rights. There are a few exceptions where C might have rights to enforce the contract, but the law usually says A can enforce the contract against B and B can enforce the contract against A, but strangers to the contract aren't going to be able to enforce rights. That's the usual rule in the law generally. But we saw with third-party beneficiaries, especially with, say, life insurance policies, that there are some exceptions, and there are important exceptions where C can actually sue to enforce the contract. This is another category of circumstances in which privity is also relevant, or there's an exception to the privity idea. Generally, a person does not need to be in privity, that is, contracted with the seller to be included under warranty provisions. So again, here's a definition of privity. An identity of interest between persons, I have a comma there, so that the legal interest of one party is measured by the same legal right as to the other. Again, we're basically talking about parties to the contract. So the UCC usually says what the answer ought to be, right? I mean, that's kind of its deal. It says, you know, hey, this is what we think is the best answer to this particular question. And most of the time, the vast majority of the time, it picks an answer. It says, this is what we recommend. Now, of course, states have the opportunity to say, we don't like that. We're going to go a different way. I mean, it's their right to decide what they're going to do, but they at least know what the UCC is recommending, or at least what the document is stating. But in the area of privity, since it's such a controversial topic, the UCC actually provided 3 alternatives. One would have been privity is required. Another is privity isn't required at all. And then there's kind of a middle setting where Privity is sometimes required, sometimes not, depending upon a more complex version of the facts. So there were three choices, A, B, or C. Texas could have picked A, or it could pick B, or it could pick C. But maybe because we're Texans, we decided none of the above. We are picking D, and this is the choice that we picked. This is actually the language in the Texas Business and Commercial Code, section 2.318. It says, chapter neutral on question of third-party beneficiaries of warranties of quality and on need for privity of contract. Here's the language. This chapter does not provide whether anyone other than the buyer may take advantage of an express or implied warranty of quality made to the seller, or whether the buyer or anyone entitled to take advantage of a warranty made to the buyer may sue a third party other than the immediate seller for deficiencies to the quality of these goods. These matters are left to the courts for their determination. So a massive passing of the buck from our legislature in Austin to our court system. And again, while you may say, what cowards our state legislators were at this time, perhaps you're right, perhaps you're not. But this is not as shocking or as unusual a thing at all, because of course, most of our law in Texas, and really all 50 states, maybe not Louisiana, but the other 49 for sure, most of the law we have is common law, is developed by the courts. So for the legislature to say, let's let the courts figure this one out, is actually not an unusual result in a common law jurisdiction. So what has Texas courts done in this area? Well, generally speaking, the Texas courts have found that privity is not necessary. Let me just go ahead and see here. Let me go to our particular case here. Take just a second break. And we have here Texas's position on privity and warranties. Just going to open this up. And this is here an excerpt from a, this is actually an appellate court in Houston. And here we have the Texas Supreme Court held in 1977 that privity of contract is not required in order to recover purely economic losses from the breach of an implied contract of merchantability. The Supreme Court, however, has not clearly stated whether privity of contract is required in order to recover purely economic losses for a breach of express warranty, and the courts of appeal are divided on this issue. So we don't yet have complete clarity on Texas's position on this issue. Sometimes it seems like there probably privity isn't required, but there perhaps are times where privity is required. So just want to share this with you. I'm not going to quiz you about the ins and outs of this. Just know that there's a little bit still unsettled in this issue. And by the way, here is that voidable title video that I mentioned earlier. So now let's flip back to our PowerPoint and go from here. Okay, so let's talk about the remedies that we need to, or that we might be available to us if we're the successful plaintiff in a breach of warranty case. Okay, so one of the prerequisites, one of the things you have to do before you can successfully advance a lawsuit based upon a breach of warranty claim is that you have to notify the seller of the defect. And I'm going to show you a letter in just a second, but before we do that, let's talk about why we need to do that. This gives the seller the opportunity to fix it. For example, my hairdryer isn't working. Well, instead of me suing the manufacturer or the seller, why don't I just call them up and say, hey, you got me a dud? They're probably going to say, or at least there's a pretty good chance they're going to say, oops, we're sorry. Why don't you just bring it over and we'll get you a new one? Oh, okay, that sounds good. Problem solved. Why go to litigation when there may be a really easy peasy, easy fix out there? The UCC does provide for particular remedies when the warranty is breached and it can't be solved simply by a telephone call. The UCC provides for both incidental and consequential damages. Remember, we talked about these categories of damages in another chapter. So let's consider we've gotten a lemon, a car that just isn't working out for us at all. Okay? So this is the scenario. We happen to be Alice Consumario, and she writes a letter to Joe Schmo, who has a car dealership called Joe's Used Car Never a Lemon Sales Group. So we have, dear Mr. Schmo, on this particular date, so you're going to see she's going to tell a story here. And that's when you're writing your letter, because the purpose of this letter is to notify Mr. Schmo about the defect. So she goes through and tells the letter. On this date, I bought a car from your dealership. I'm very pleased with the purchase and the 120-day no problem warranty that I purchased for an additional $100. So there is a warranty here. I'm going to do a different color since here. So we've got this warranty here to focus on. She's attached the various documentation. Good idea when you send this letter, not the originals, of course, but copies. 6 days later, so we're still easily within our 120-day window. 6 days later, the car stopped running as a result of a steam cleaning of the engine your company did as you prepared the car for resale. As a result, I was forced to pay for the car to be towed and the spark plugs and wires replaced. In addition, I had to stay overnight because the parts were not available on a Sunday. The total cost was a little over $1,000. The problem occurred when I took the car for a trip to Boston on the 9th. So, so this is, as you can see, let's see, October, November, December, January, February. So we're getting on February 9th, we're getting very close to the 120 days point. On Sunday, the 10th, I was driving back. The car stopped running outside Hartford on a major highway. I had to have the car towed to the closest Toyota dealership, a copy of the bill. So again, she's attaching the bills, and we can see it's $120 there. When I arrived at the dealership, the mechanic looked at the car and ran various tests. He found that the spark plug wires had been corroded because of water being forced up into the plug wire coverings. He said this could not be the result of road wear because water cannot be splashed up into that area. I'm enclosing a hand copy of his handwritten statement plus a copy of his business card. He said he would talk to you if you called. Their dealership no longer steam cleans engines because of this problem. In fact, Toyota has a service bulletin that says this is not a good practice. The bill for the repairs the rental came to, and to get to a hotel was this amount. Again, there's receipts provided. I have the actual wires and plugs that were taken out, and you can look at them. Another good idea. Because the parts were not available on Sunday afternoon, I had to stay overnight until Monday so they could get the parts. Again, she spent $84. The Never a Lemon sales group is responsible for these costs for 2 reasons. First, the warranty says this car stops operating for any malfunction not due to wear and tear, which this one supposedly isn't. Not a Lemon will make the repairs for free and provide towing. Because it happened out of state on the weekend, I could not call you and had to go ahead and pay for the towing and repairs myself. The car stopped 118 days after I bought it. This was 2 days before the warranty expired. Second, you should pay for the hotel costs. I would not have had to stop in the Hartford overnight unless I was forced to because of the car. So this would be an example of an incidental cost, right? Last week, I spoke to Andy in your business. He said the problem was regular wear and tear and that you would never pay for someone to stay in a motel. I am writing you because I know you will understand that this was because of your steam cleaning the car that broke down. If we have to go to court, I feel my case will win and will just cost you more money than the motel bill. Please respond by March 10th, or I'll be forced to go to court. I'd like to resolve this in a friendly way. So this is an example of a pretty effective warranty demand letter. Now, obviously, this is a consumer writing the warranty demand letter. This would be different than what a law firm would provide, but it gives you a sense as to the types of things you want to do. We talk about the facts, we provide documentation, and you give them a deadline. You got to do this by a particular date, and you explain what you'll do next. And it should be in a professional tone, but clear, a professional but clear tone that you want this problem resolved in a particular way. So when you have a warranty claim, you also oftentimes will have claims that can also arise under tort law or under contract law. So we kind of see a tort law and there's contract law. The kind of in between is warranty law, which is a bit like tort law and a bit like contract law. And many times the plaintiff will choose to sue under all three of those theories because there's some advantages and disadvantages from a legal perspective for each one of those choices. So by suing for under all three of the theories, kind of the idea is that the plaintiff is going to maximize the potential for a good recovery. Okay, so the likely negligence, or likely tort claims that would come up would be negligence, and possibly strict liability. So negligence would come up as a tort claim. So we're not talking about contract law here. Tort is a separate area of the law. You will learn about tort law in course LGLA 2303, which is called Tort and Personal Injury Law. So this negligence arises when the defendant has been careless in some sense as to how he or she has handled a particular situation, and the plaintiff has suffered a loss as a result. So what is negligence? The failure to do something that a reasonable person, again, whenever you see the word reasonable, think objective standard. Not just what I think is reasonable or what you think is reasonable, but what the average person would think is reasonable. So again, the failure to do something that a reasonable person would do in the same circumstances, or the doing of something a reasonable person would not do. I just left off the word reasonable person here. Sometimes, though, you can sue under a strict liability claim, and this is available. It's in some sense a better avenue because you don't have to prove negligence, but you do have to, you're typically able to advance this claim only if the product itself is unreasonably dangerous. So strict liability is liability for an injury whether or not there is fault or negligence, absolute liability. In other words, if something goes wrong, the defendant is basically an insurer for the plaintiff. I know that these terms and this whole concept I'm just barely touching on. Again, this is something that you would cover for several weeks during a tort class. So if you haven't taken torts yet, I recognize I'm just barely touching the surface here, but this is all you need to know, again, for this course, because this isn't a torts class. You will learn much, much more about this as you get to torts. And of course, issues that could come up under breach of contract would also be available to the plaintiff in addition to a warranty type of claim. So at this point, if you have any questions, feel free to reach out to me. My email, of course, is cgroover@collin.edu. I would love to hear from you. Otherwise, you're welcome to stop by and we can talk in more detail about these topics. I hope that you found this presentation interesting and helpful to you as you prepare the material in this course. I thank you for your time and attention. Have a wonderful day.